Good afternoon, Judge Shapiro. We're about a minute out, and we do have, it looks like, representatives for all the different groups that we have, so I can start bringing them in since it will take a while.
Sure. And why don't you just let me know when they're all in, and I'll come back then. Okay?
Okay, I'll let you know when they're all.
Great.
Hi, Carl. It's Teresa. How are you?
Hi, how's everyone?
Okay. Good to see you, Carl.
Good. Yes, good to see you.
Okay, Judge Shapiro, it looks like everybody is here.
Thank you. All right. Good afternoon, everybody.
Afternoon, Judge.
Good afternoon, Your Honor.
All right. Well, once again, we have a crowd, and a lot and a little has happened since we last spoke. So, and apparently I missed the absence of somebody last time, and I don't want to do that again. So I want to just go, I'm going to call everybody, tell me who you represent. All right. And then I'd like if anybody you think is missing, you let me know. Mr. Colson, who do you represent?
Good afternoon, Your Honor. I'm co-lead counsel for the plaintiffs.
Right, but which plaintiff did you originally represent? Which is
the Kavanaugh plaintiffs, as well as the Janssen-Rogers plaintiffs.
Okay. All right, Mr. Chalos.
Good afternoon, Your Honor. Also co-lead for the plaintiffs. We represented the Brazil plaintiffs initially.
Do you, okay, got it. Okay. Mr. Gamble, I know who you represent, the state, right, and various entities. Mr. Talley, who do you represent?
I am with the Brazil plaintiffs as well.
All right, Mr. Edwards.
Brazil plaintiffs, good afternoon, Judge.
Thank you. Ms. Hazelcorn.
I'm with the Hasselkorn's correct. I'm with the Brazil plaintiffs, Your Honor.
Okay. Ms. Martin.
I'm with the Brazil plaintiffs as well, Your Honor.
Okay. Ms. Jennings.
Yes, good afternoon, Your Honor. I'm with the Brazil plaintiffs as well.
Okay. Ms. Lamore.
Good afternoon, Your Honor. I'm here on behalf of the state.
Okay. And Mr. Beeson.
Yes, Your Honor. I'm here on behalf of the grant plaintiffs. I'm an interested party from the federal courts.
The which people?
the grant plaintiffs in federal court, Your Honor. I'm here in support of the
Janssen Federal
plaintiffs.
Court.
Correct, yeah.
Okay.
That's right. And Your Honor, I asked Mr. Beeson to join today in light of some of the arguments that the state made in their filings. If necessary, he can address those as well as it relates to the argument that we are attempting to poach somebody else's clients.
Sure. And Ms. Smith, you're here also for the state?
That's correct, Your Honor.
Bettenhouse, I know you're for the state. Okay.
Thank you, Your Honor.
Is there anyone else? There's another box on there. Is there anyone I missed? Okay. So we have people representing the state. The plaintiffs as a group. We have Mr. Colson originally with the Kavanaugh and Janssen-Rogers case. We have several from the Braziel case, which covers the 3 original complaints in this case. And we have Mr. Beeson, who's here from the Grant case in federal court. Do we have anyone here from the Mitchell case in federal court?
No, Your Honor, that's Mr. Stern's client, and he was not able to join today, but he has, we had a meet and confer yesterday with everybody. He also sent a letter to the state outlining his position, which is consistent with what I think Mr. Beeson and what we will say as well today.
All right, a few background questions before we get to things. So other than these interrogatories and the request to produce that were sent to the defendants, has there been any other requests for discovery?
No, Your Honor, other than we've made our initial disclosures and the state's made their initial disclosures, and we're having some discussions about the completeness of ours, and we'll have discussions about the completeness of theirs. But otherwise, no, we have not yet propounded any additional discovery.
All right, Mr. Gamble, if you could speak for the defendants, do you agree?
Yes, I agree with that position. There haven't been additional discovery requests made, but the parties have made initial disclosures. There are discussions ongoing from the defendant's perspective about whether the initial disclosures are complete from the plaintiffs, and so we're still waiting for additional information from them.
All right. Could either Ms. Edwards, Mr. Edwards or Ms. Jennings bring me up to date on the federal case?
We have a status conference, as you know, Judge, that was canceled to discuss the discovery issues. And so what we're waiting on now is from, this is Carl Edwards, by the way, we're waiting on Judge Green apparently to rule on the motions to dismiss that have been filed, the 12B motions to dismiss that have been filed, and or to tell us whether or not he's going to permit some discovery before he decides those motions.
Right. I know his initial view was he was going to let some discovery go, but apparently he determined that he wanted to rule on all these motions first.
That's correct, Judge.
Okay. Anybody want to chime in or disagree with Mr. Edwards' description of the federal case? Okay, hearing none. And as I look at it, I see that the Mitchell case and the Grant case, I mean, in fact, all the federal cases, I'm not sure there's any overlap of defendants. Certainly there are issues, but it looks as though there are different sets of defendants. Am I missing something? Are there some defendants that are in both cases?
Yes, Your Honor. The state agencies are defendants in both the state court and the federal court. The Brazil plaintiffs they voluntarily dismissed the claims they had filed against state agencies, but the other cases in federal court, at least one of the other cases, is still against the state agencies. So the defendants are parties, and the Brazil plaintiffs are parties in both courts as well.
Right. And Mr. Beeson, in your case, are the DHHS and EGLE still in the case?
Yes, they are, Your Honor.
All right, very good. All right, so I'm going to hold off on the motion for now, but I'm going to get to it. First, let me ask about I'm trying to track the federal court here a little bit, and perhaps I made an error in not immediately ruling on the SD motions. I have SD motions in which everyone has filed, initial response and reply in Janssen-Rogers and Kavanaugh, but of course not in the consolidated and not in Braziel. Also, I think I issued an order that there could be supplemental briefing on the Bowserman or Mays issue, and I don't think I received any of that. Perhaps it would be wise for me to get those motions finalized and decided, both to try and get on track with the federal court, and also because it makes sense if there is somebody who's going to get out that we address that now. Let me hear from the plaintiff side as to your view on whether or not that's a good way to proceed, and how long you anticipate that taking.
Okay, this is Mark Chalice, Your Honor. Yes, we would be fine with proceeding that way. Although I guess we're in a little bit of an awkward procedural posture in that we now have a consolidated complaint that may obviate some of the issues that were raised in prior pleadings. So I wonder if we need to refile that motion. I'd like to hear what the state has to say about that, but that might be what we need to do.
Mr. Gamble or Ms. Smith, Ms. Bettenhouse, where are you at on that?
Your Honor, we believe that the motions for summary disposition that were filed previously in the state litigation are now outdated because the pleadings that those motions attacked don't exist anymore because we have a consolidated complaint.
Sure.
And so I share Mr. Chalice's concern about kind of the procedural posture of this. And the motions for summary disposition, from our perspective, those have essentially been withdrawn. I mean, we can formally withdraw those if that would help the court kind of get a better idea of where things are at in the case.
Well, if you withdraw them, do you anticipate refiling an omnibus SD motion?
I think we will eventually, Your Honor. But we thought that we went ahead and filed an answer to the consolidated complaint. And so I think that eventually we'll file an SD motion with the court. But at this point, I think it makes sense to wait and see what the federal litigation is going to do, how the court will rule on those.
Although, I mean, it doesn't seem to me that, is there something that's pending in the federal court that might be preclusive?
I really don't know because I'm not sure what the federal court's going to do, but I think that there could potentially be issue preclusion concerns that could have a bearing on this court, but I really don't know, Your Honor. We can't take a position on that. We just don't know what they're going to do. So that's part of the reason we went ahead and filed an answer was to try and take things one step at a time. And rather
well, I have no problem with you holding off an SD motion, and I imagine the plaintiffs don't have a problem, although they can speak for themselves. So that leaves us in the situation where we're all waiting for the federal court ruling, which Magistrate Green told me about 10 days ago or so that he thought it would be 30 days. At which point I suppose we could consult and try to set up a joint discovery order, but we're just sitting here at this point for months twiddling our thumbs, which I'm not crazy about. So Mr. Gamble, am I saying your name right, Gamble?
Yes, you are, Your Honor.
What is that your expectation that we should just hold up, you want the stay of discovery to the degree that it's been underway just until the federal court makes a decision and then we take it from there?
I thought our request, Your Honor, is to put this state litigation back on the trajectory it was after the October 3rd status conference, which was essentially what the court just described, which is that once we know how discovery is going to proceed in federal court, that this court should be involved in that process and should be participating in status conferences with the federal court. So we're all doing this together and there isn't this miscommunication and this difficulty back and forth. And so, from our perspective, we thought that issue was resolved because virtually all the plaintiffs in the state litigation filed a joint proposal with us in federal court on October 13th, explaining, saying, we jointly propose that discovery be centered in federal court, that discovery disputes be resolved by Judge Green. We think that's the better pathway for this rather than having two separate discovery paths.
Well, I don't know how Judge Green can rule on evidentiary or discovery issues that don't relate to the case that he's got.
Well, that's one of the ways that the parties thought we could resolve that was to deem parties who weren't in federal court interested parties. So deem them interested parties in federal court. That way you have a single judge who's able to adjudicate issues, because as the discovery requests that the plaintiffs issued here illustrate, they really have a hard time making requests that don't implicate the federal litigation. And the same would probably be true for discovery requests issued in the federal litigation. It would implicate, for example, the Kavanaugh, the Janssen-Rogers plaintiffs potentially. And so it just makes sense. And we all agreed, I thought, that it makes sense to center discovery in a single court, have those disputes resolved by a single judge, rather than have them on two different tracks with potentially conflicting decisions. That's really all we're asking with the protective order, is just go back to the trajectory this case was on after October 3rd, that the parties on October 13th agreed to, which was to center discovery in federal court. And so I think it would make sense. This is the first we're hearing, Your Honor, that Judge Green would have a decision ready so promptly. But presumably,
well, don't count on my word. You know.
Well, I my point is simply, Your Honor, that it would make sense to me to just wait a little while longer until we figure out what's going to happen in federal court, and then if he wants to move forward with discovery planning, have this court involved in that directly, which is what we had proposed last fall.
So, well, first, let me stop there. Any of the plaintiff counsel wish to respond?
Yes, Your Honor, I do. So I don't think it was ever our contemplation that discovery would stop for as long as it has so far. Our contemplation, and I don't agree necessarily with the characterization of what was filed in the federal court, but leaving that aside, our expectation was that we would move somewhere on discovery. We thought we had a path in federal court that was moving fairly quickly, but when Magistrate Judge Green rules on his motions, we'll have a period of time where we're going to have to hear from the district court probably on those same motions, and no telling how long that process is going to take. Now, I don't expect that we're going to get rulings on those motions that says your case is over. You have no path for these people who have had contaminated water for years. I don't expect that to be the case. And even if there are some parties dismissed there, and there might be, they're still going to be third parties subject to third party discovery. So we're not contemplating doing anything that's wasteful, certainly. But I think our contemplation all along has been that we wouldn't get this chicken or the egg problem persisting for months, or in fact, it's over a year. The first case was filed in December of 2021. Our case was filed, I think, in May of 2022. We're coming up to a year in our case. Our contemplation was we'd move somewhere. And here we are. It looks like, at least for the time being, the state court is where we're going to move. Now, to the extent there's a coordination issue, we've got that handled. We've got Mr. Beeson here. Mr. Stern is working with us as well. Nobody's prejudiced in any way. No one's complaining except for the state complaining on behalf of the other plaintiffs. Nobody asked them to complain on behalf of them. So we'll coordinate. We can do it here and we'll coordinate. We don't have any problem with that.
And Your Honor, I just might add briefly, because it's our two sets of clients that are not present in the federal litigation, that we've never agreed to forego any of our rights in the state court litigation based on something happening in the Western District. And indeed, one of the several reasons that we didn't file in the Western District is our concern about, frankly, the staffing there and the ability of these cases to be timely managed and get through, and us to be able to get discovery and do something with this case in a way that's going to be done in sometime this decade. So, from our position, it's the defendant has answered in this case. We're very eager to get started on substantive discovery.
So what is your proposal then, the plaintiffs, about coordination if the federal court doesn't start moving to discovery? how would it take place here, such as to be coordinated with the federal cases?
So we, Your Honor, filed in October in this court a proposed discovery coordination protocol.
I have one from the federal court. I don't recall seeing that here in the state court, but that's okay. Keep talking.
Yeah, it was Exhibit B to our filing.
Okay.
I don't know the filing number. Maybe Ms. Hasselkorn can tell us what the filing numbers. But the idea would be that the order primarily focuses on depositions, but I don't think we're quite there yet in terms of depositions. But in terms of filing, asking for documents and asking questions through interrogatories, we would involve Mr. Beeson and Mr. Stern. I mean, it's a finite universe. There aren't hundreds of other people out there. There's, basically 3 lawyers handling the federal side on the plaintiff side. We'd coordinate with them, serve discovery here that are primarily focused on the claims in the state court, in your court, but give them a chance to weigh in on it. And of course, give them the benefit of any documents or any information we learn. We'll enter a suitable protective order to the extent that there's personal medical information. We would handle that appropriately through HIPAA releases and through adequate protections so that maybe their lawyers are the only ones that can see their names, for example, which is what we proposed. I know we're not on the protective order, but that's one of the solutions we proposed there. But it's a finite universe. It's a relatively small group. We're all working cooperatively together. We can manage it.
And are any of the defendants in the state court, in the federal court, represented by anyone other than the AG's office?
Yes, there are 2 private companies that are in the federal litigation.
Einhorn or something, yeah.
Yeah, that's right. And we can involve them as well. And we can involve them on the same terms, that they would have to enter the protective order and they'd have access to all the information. Now, obviously, we wouldn't involve them in the process of crafting our discovery requests, but they would certainly benefit from the discovery. And if they feel like their rights are being compromised, for example, that the state's giving information to us that is proprietary to them or something, they can weigh in. But I leave the defendants to coordinate, I guess, among themselves. But certainly on our side, the plaintiff side, we can coordinate. We've been coordinating.
Just to clarify, sorry to jump in. I believe it's actually 3 engineering defendants, private companies, because Abermarsh was added, and it's also the EPA as well as the City of Harbor defendants. So there's quite a few other defendants that are not represented by the AG's office. Sorry to interrupt you, Mr. Talos.
No.
I appreciate that clarification. You're correct. That's correct, Your Honor.
All right, one moment, please. Oh, just another issue on my list here. What about the minors? Do we have next friend appointments? What's the status of those?
So we don't represent minors, Your Honor. In our case, ours is the class case. I assume what they're referencing are Mr. Beeson's clients.
I believe the Brazil I believe the Brazil plaintiffs represent 13 unnamed minors. Am I mistaken?
That is correct.
Oh, I'm sorry. You're absolutely correct. You're right. Thank you for that clarification, Mr. Campbell. That's right. That's right, Your Honor. Those are part of the Brazil group.
Well, don't next friends need to be appointed even though it's a class action? I frankly don't know, but I would assume if a minor is involved.
They do, Judge, and we'll cure that.
Okay.
We'll have them appointed through probate court. We'll cure that.
All right. Okay. All righty. So, I'm not going to give you a great. Oh, on the motion. Sorry, before I forget. All right. So I'm gonna call the motion in this case. Now lost the case number. Well, it's the 3 consolidated cases, or the omnibus case 21-246, 2246, and 2250. Mr. Gamble or Ms. Bettenhouse or whomever, do you want to say anything else about a protective order other than what you've made clear in our discussion?
Your Honor, just to say that this type of discussion is, I think, very productive, and is really what we're asking for in the protective order. The only thing missing is that there are lots of attorneys who should be involved who aren't. And so that's why our proposal is to, unfortunately, I know that the plaintiffs are very anxious. I think the court is also anxious to kind of move things forward, but I do think that the wiser trajectory here is what the court decided on October 3rd, which is wait for the federal court. They're going to make a decision. At some point, we're going to be able to get all the attorneys in the room who have an interest in this, because it isn't just the EPA, they're individual EPA defendants, and it isn't just the city of Benton Harbor, they're individuals who have also been sued. There's a large number of attorneys and parties who have an interest in this discovery process who are not here in this room right now. And so really that's what the protective order, that's all we're asking for is, look, we provided the information that we thought the court was concerned about at the November 14th status conference. We provided that information to the plaintiffs, and now let's go back to where we were on October 3rd. And
I understand your argument, just so it's clear from my perspective. I mean, the anticipation was that the federal court was going to, be done on ruling in December, and then in January, and then in February, and now in March. And so, the expectation was that we would delay things for some time. It wasn't really my expectation that we would delay things for 6 or 7 months. But of course, that horse is out of the barn, I understand. Well, I don't know who wants to speak for the plaintiffs on the motion. Basically, my question to the plaintiff is, have you received the answers? I know there were tons of, objections, but they also provided you with some materials. Were the answers inadequate?
They were inadequate. Yes, Your Honor. So what we've got back is essentially 4 pages of documents in response to our request for production. And we served 4 interrogatories and we got back 0 answers, just a slew of objections. So no, we're not satisfied with the responses. We had a meet and confer yesterday, and I'm not sure we made much progress, but we talked. And one of the issues that I offered to take off the table, at least with respect to this initial set of documents, is with respect to the putative class members. And that was something that was giving the state quite a bit of heartburn. And my proposal to them was, well, then let's confine these questions for now. And I say for now, with respect to these particular documents, to just the named class members. And I'll leave it to the state to respond, but we didn't get the sense that
that's 4 or 5 people. Is that who you're talking about?
Well, all of the folks listed, and we can give them the names of the minors, but that's right. The named plaintiffs in the case. And, I think that, and when I say that, I want to be clear, I'm not suggesting that we agree that we're not entitled to discovery regarding all of the members of the punitive class. We think we are, but I want to be sensitive to the wording Your Honor used in your order authorizing this specific discovery, and you use the word plaintiffs. And we read that broadly. They're reading it narrowly. We can read it narrowly for purposes of resolving this dispute today, and just proceed on that basis. And it may be that there are only 4 documents that relate to those folks. I am not satisfied from our discussion yesterday that the state discharged its obligation to do a thorough search. I think they read our requests incredibly narrowly and too narrow with respect to the documents. With respect to the interrogatories, they didn't answer at all. There's literally no answer in there other than a bunch of objections. My proposal yesterday was, well, if we just restricted this to the named plaintiffs, will you answer them? And I think their answer basically was no. We still have other objections to these. So we would like answers. We're not satisfied, particularly with the interrogatory responses, and we're not satisfied on the documents that they searched for what we've really asked for. They've given us 4 documents that relate to actual results of lead testing. Our requests are broader. We want to know what kind of questionnaires, what were the protocols, who's out here asking questions of our clients, what instructions were they given, what communications they had with our folks. Did our folks fill out a questionnaire? Did they give information to these interviewers that was then entered in a computer system? We'd like to know the answers to all that.
Okay. Any further response?
Yes, Your Honor. If it would be helpful to the court, I can share my screen and show the information that we provided to the plaintiffs.
Oh, I have it right in front of me.
Okay, and so if
Your Honor, just something other than what you attached to the, I see the 4 pages or whatever attached to the request to produce, and I see your answers to derogatories.
So the table on Exhibit 4, page 7, the table that we have there, Your Honor, it outlines the 10 named plaintiffs in the consolidated complaint. And it explains that there are 4 different programs by which the state agencies would have interacted with these plaintiffs.
Mr. Gamble, is this what you're talking about? Let me see if I can get this in front of the camera. I don't know if you can see it.
No, Your Honor.
I don't know.
I could share my screen if it would be helpful, but
Please.
Is that okay? Okay.
If you're capable of it, I wouldn't know how to do it.
Yes, I can. And so this is,
I can. Yeah.
okay. So this is what I'm talking about. And Mr. Chalice is just very surprised by the small number of documents, but that's because there aren't any. I mean, I'm not quite sure. I asked him yesterday to explain to me why he believed there had been so much contact between the agencies and his clients, and he wouldn't answer that question. But the fact of the matter is that for the Lead Safe Home program, the plaintiffs asked for Eagle and DHHS to look back to November 10th, 2021 and say, has there been any information with the Lead Safe Home program and these 10 people? And the answer is no. There was no contact from November 10th, 2021 forward, the Lead Safe Home program. No one asked for state agencies to come and do an inspection of their home. There's no record of it, at least in the database that collects those applications. Well, what about, and they didn't ask this, but we went above and beyond what they asked for. And what about the childhood lead prevention poisoning program? And from November 1st, 2021 forward, there was only a single person of the named plaintiffs who had their blood lead tested. We held back that document because the plaintiffs hadn't provided us with the authorization under HIPAA to provide it to them, and they still haven't. And then what about the drinking water group in DHHS? They looked back on their data going back to November 10th, 2021, and about 4 or 5 months before Ms. Brazil or Ms. Branscombe filed their lawsuit here, someone from DHHS had provided filters to those folks. And then only one person, again, about 4 or 5 months before they filed their lawsuit, had their water tested, and that was Ms. Brazil on December 16, 2021. So Mr. Chalice is surprised that that's all there is, but that's all there is. And so to give you an example, however, of why the requests are really difficult to answer, I can show you what it looks like when you spell out their requests with all the definitions they include. Like, for example, here's interrogatory number 1, and if you just read it, it seems reasonable enough, but virtually every one of these meaningful words have some complicated definition. And so when you take the definition and lay it out, this nearly full page, that's interrogatory number 1. And so our objections are like, look, this is too broad. You are asking for stuff that is beyond the scope, that is not proportional to this very narrow request that Judge Shapiro allowed. So, the plaintiffs have not filed a motion to compel to address each of our many very specific objections. I would welcome it if they want to, then we would have an opportunity to fully brief the court, and the court would have the benefit of a full briefing on these issues, and then the court can have another hearing if it wishes. But really, we don't think that the response to our request for protective order is the correct place for them to try and kind of do a backdoor motion to compel here. But my point is we provided the information that the court was concerned about at the November 14th status conference. And our objections relate to the breadth and complexity of these requests and we have made those known. They haven't filed the motion to compel. If they want to do so, we will happily respond, and then we can work it through. And if they want to reword their request so that they use ordinary language that normal people use to communicate, we can do that and get to the bottom of it. But Your Honor, I'm not exaggerating.
Well, I understand definitions and interrogatories, but I'm not sure communication is all that complicated. There's phone calls, there's texts, there's emails, and there's face-to-face contact. I don't know why that's too complicated to answer.
I'm with you, Your Honor, but that's not how it's defined in the request. The request define it in an almost unimaginably complex, difficult way. And so that's the objection. So if they want to rephrase, or if they want to file a motion to compel that where we can work through these, that's fine. But this is not, in our opinion, the proper posture for this type of dispute to happen, because they haven't filed a motion to compel. We timely answered the requests. We gave them the information the court was concerned about. We made specific objections to the areas that we thought were objectionable. And now the ball's back in their court. So if they want to file a motion to compel, they can, and we can work through these things.
So Your Honor, I'm sorry, may I respond?
Yes, you may.
You're seeing a little glimpse of the sort of frustrating situation we find ourselves in. In my practice, if we got a set of discovery requests and I felt like there was something improper about the definitions, I'd pick my phone up and say, hey, we're going to interpret this according to the common meaning of the word communication, and we'll give you some responses. I wouldn't say, aha, file your motion to compel, and we'll see what the judge says. As a procedural matter, Michigan Rule 2302 under protective orders allows, Your Honor, if the motion for a protective order is denied in whole or in part, the court may, on terms and conditions as are just, order that a party or a person provide or permit discovery. And that's what we've asked Your Honor to do here. So we're trying not to create work for everybody by filing motions. We just want a resolution. We want the information we've asked for. If Mr. Gamble doesn't know what communication means, he can call me and we can come to some resolution of that. I tried to do that yesterday. We didn't get anywhere. But with respect to, let me go back to the substance of that chart, for example. Some of the entries there on page 7 says that the state installed a pitcher filter, installed a faucet filter. We don't have any explanation for what that means. But more importantly, I represent states in litigation. There is not a chance that the state installed a filter on a citizen's home without there being quite a bit of paper around it. Somebody had to ask for it. Somebody had to get the okay to do it. There's got to be a lot more paper than just a chart that the lawyers made saying install filter. Among the 4 pages that they provided, there's not a word about that. There's not a word about installing the pitcher filter. So I'm not sure what they're talking about. Secondly, there are the minors, which we'll provide them the names. We'll go through that process so we can get the information to the extent there's any more information about them. But they're only talking that so far about the first 2 document requests. There are additional document requests for which we've gotten absolutely no information. We've asked, for example, let's see the agreements between you and the testing people that went out and did the testing. We'd like to understand the scope of what they did. Were these people instructed, for example, go out to these people's houses, get a questionnaire filled out, ask them, have they had any adverse effects from lead? We don't know, but we'd like to see the terms on which these various contractors were engaged and what their instructions were Same with requests to samples taken. We have some 4 pages of sample results, but let's see the protocols for how these samples were taken. How did these people decide who to test, when to test, where to test? What kind of testing was run? We see examples of results, but there had to be some protocol. I mean, states do business with lots of paper. We all know that. The idea that there's only 4 is surprising. That's why, Mr. Gamble, I'm surprised by that. Request number 5, what are the policies, procedures, guidelines, protocols related to the lead testing? Number 6 are requests. What are the communications that anybody who's doing this lead testing had with the plaintiffs? Again, did they fill out questionnaires? Were they asked questions? Did they bring an iPad with them? and fill out information? Did they write it down? We'd like to understand what that looks like, and we'd like to have those documents. The idea that for this program, where by the state's own admission, there's at least 4 contacts with our named plaintiffs, there's got to be more than 4 pages. And that's just the document request. We asked for similar information in the interrogatories and gotten no responses at all. Not even a C, our document, nothing, just objections, boilerplate, including objections like, it is a fishing expedition in which plaintiff attorneys hope to identify potential new clients. That's not a defense to providing information recognized by Michigan law. So in any event, that's where we are, Your Honor. We ask that Your Honor order them to respond. Again, we'll take off the table for now putative class members who are not the named plaintiffs here and the minors, but we ask that they have to engage with these to back up, zoom out. It's clear the state didn't engage with these requests. They just slapped on some boilerplate objections, threw 4 pages on there, stapled it and sent it back to us, and then filed a motion for protective order. They need to engage with these. We're happy to sit down, walk through these. If there's some words in here that they think are not clear, we'll come to some resolution. But we'd like for them to have to answer these in a meaningful way.
Okay, anything else from anybody? All right, here's what I'm going to do. I am going to direct the state to respond to the pending document and interrogatories, limiting it to the named plaintiffs. I'm going to, other than that, I'm going to indicate that you shouldn't submit any further discovery. I'm going to contact the federal court again, and hopefully we can have a meeting with everybody. And if not, at some point I'm going to have to let this go. But I understand the problems of the coordination, which is frankly a little bit beyond me, and what has to be done. I'm not thrilled about the idea of turning over all the decision-making to the federal judge when state court rules are at issue. But I'm happy to discuss that in a meeting with the federal court and with all the parties. So I'm going to issue an order directing the state to provide complete answers to what has already been filed, and that no further discovery should be submitted until further order of this court. And hopefully we will coordinate with the federal court. And it sounds like everyone's willing to be cooperative in that. It's just a question of time.
Your Honor, may I ask for one clarification? We made our initial disclosures. The state made its initial disclosures. We're engaged in a process, which I hope will be productive, where we're going to provide some supplemental information. We're going to ask the state to provide supplemental information as well. We think their disclosures are not complete. We'd like for that process to continue, notwithstanding Your Honor's temporary stay of discovery otherwise.
Do you wish to speak to that, defense?
Your Honor, I don't think that initial disclosures are necessarily the type of discovery the court's referring to. So we have no objection to continuing the initial disclosure process.
All right.
Right.
All right. Very good. So I would ask that both parties do that. And if you need to bring it to my attention, I hope you won't. I know I'm on the record, so let me make clear that that was a poor joke. Of course, if there's any problem,
understood, Your Honor.
we have to rule on it. Very good. And I'm going to call Magistrate Green after we complete this, and hopefully he and I. What I'd like to do with him is to get a joint status conference set with everybody present. And I don't know, has he been doing them live or in by Zoom?
Live, Judge. Live.
Yeah, live in person, Your Honor.
All right. Well, I will talk to him today and ask him if we can schedule that to occur, to schedule it now promptly after the date he thinks he'll have his recommendations to the trial court.
And Your Honor, can we have a date when the state will have to produce this ordered information? 24, 21 days, 14, whatever, or maybe the parties can agree to it.
21 days is fine. Mr. Gamble, is that a problem?
Sorry, Your Honor, just checking. 1, 2, 3. That'd be March 16th. Yes, I think that would be fine, Your Honor, 21 days.
Well, actually, that's 28 days.
Oh, sorry,
But,
did I get it wrong?
But 28 days will be fine.
Thank you, Your Honor.
Okay. All right, I'll issue that order. And if there's nothing else, we'll conclude. But if there is something, please indicate.
There is, Your Honor. There's one scheduling issue that I think Mr. Colson and Ms. Hasselkorn may want to raise.
Yes, Your Honor. This is Amelia Hasselkorn. Plaintiffs had hoped to just quickly resolve a question about the schedule moving forward. Of course, discovery deadlines are not set at the moment, but we just wanted to ensure that everyone is on the same page, at least about a class certification motion that will be filed by plaintiffs eventually.
And Your Honor, yeah, we have, sorry, didn't mean to cut you off, Amelia, but just because I know I owe you an answer on this, but we have various different stipulated class certification deadlines pertaining to the 3 original cases. We've not done that as it relates to the consolidated amended complaint. So it would be, frankly, I think it would be our preference if we just had an agreement, hopefully, or an order to suspend indefinitely that deadline pending the opportunity to conduct sufficient discovery to enable the court to rule on class certification.
Well, you know, right now it's the deadline is July 28th, right?
That, Your Honor, was entered in the Braziel case, but that was an order that was entered on August 2nd, which was a month prior to when the cases were consolidated.
Is there a problem with leaving it on July 28th for the omnibus? And if you need more time, because discovery has been delayed, which I'm well aware of, then you know, we can do that then. I don't really want to leave it without a date at all.
I would expect, Your Honor, that a July date is unlikely to be the actual date, but if we had an agreement by all parties or the order of the court that date applies to the consolidated amended complaint, then I think that would at least solve the problem.
You were breaking up and I didn't hear. I'm sorry. You said that you don't think July 28th would be the date, but
if we had an agreement between all parties or an order of the court that date applied to the consolidated amended complaint, that would at least take care of the issue in the short term. We don't want to have the argument made that the consolidated amended complaint reset the deadline and that, you know, we're now coming up on a class cert deadline.
All right. Well, Mr. Gamble or Ms. Becknoff, anything on this?
Your Honor, I think the parties can probably reach a stipulated order on this issue. This is the first I'm hearing of it. If Mr. Colson wants to reach out with the proposal, I'd be happy to hear it.
Is that okay with you, Mr. Colson?
We will do that, Your Honor.
Very good. In the event that an agreement is not reached, you'll have to file something, and I'll either apply the July 28th date to everything, or depending on how discovery is started or not started, I may extend it.
Thank you, Your Honor.
Okay. Anything else? Well, I look forward to seeing you all in Grand Rapids.
All right.
More productive.
Yes.
Thank you.
Okay. Thank you all very much for appearing. I appreciate it.
Thank you, Judge.
Bye-bye, everybody.
Bye, Teresa.
Bye-bye. Bye, Alice.